welcome to The Law Matters. Of course it does. Hi, I'm Debbie Moraes, your host and moderator. This program's been created to educate, inform, and help you with law matters because the law matters. Understand the law better, and you're in a better position to decide how to protect yourself, your family, and your business. As we say regularly, we're here to help you determine whether or not you might be able to handle some issues yourself. We provide information, insights, resources. We hope that they help. If you do decide that you need additional outside professional counsel, you'll be better prepared, and so will the professional you select. Our goal, of course, is to help you achieve the best possible results and hopefully save time and money while doing so. The Bazar and Associates law firm in East Providence have once again decided, thankfully, to donate their time, their experience, their insights on the various issues that we tackle. So we want to begin by thanking and welcoming David Bazar.
Thank you, Debbie.
Bazar. Last segment, we started talking about real estate, particularly residential, purchasing, leasing. Now, instead of what you need to know, what you need to cover, FAQs, do's and don'ts, now we're going to talk about the commercial real estate side of things. Again, what should you know? What do you need to know to protect yourself, your interests, contracts, insurance, disclosures, countless things. So let's start by David giving us a little bit of insight on what is commercial real estate? How does the industry work? The players, how do they work?
Okay, so we spoke a lot at length last time about residential issues and real estate transactions, including purchase and sales agreements and things you need to look out for when you're buying a home and that type of thing. And commercial real estate really is similar in many ways, but of course there are differences that will apply only to commercial issues rather than residential in this sense. For example, leasing issues are much different. There are many other issues to consider in a commercial lease as opposed to a residential lease. There's different things to consider. We talked a little bit about zoning before, but zoning is much more important in a commercial lease in the sense that you need to make sure that whatever business you're putting into the location is properly zoned to be allowed to operate in that location. So there are many of the same things we might cover, but there are certain things that are specific to commercial leases.
So if I'm buying a home, as we were talking about, I might use a real estate agent. Some people buy and sell on their own, of course, but there are real estate agents that are working specifically with commercial properties. There are brokers. What are the differences? What are the similarities? And who needs them and when?
Agents versus brokers? That
Yes.
type of thing. Okay. So typically an agent has to work for a broker, at least specifically to have a time frame to be able to operate on their own. But usually there's a real estate broker who employs agents that work for them. Those are the ones who will take people to the homes or the businesses, the locations to show the property and sell the property with the direction of the broker overseeing the whole operation. And what happens is you have different licensing regulations. So an agent is licensed with an agent's license. A broker has a more serious or in-depth thing to go through to become a broker. And they work together, usually.
And they have to split commissions, presumably, depending on who's showing, listing, or whatever.
Right. Now, this actually now becomes a very interesting issue for the person using the agent or the broker. Who do they work for? So there's listing agents or listing brokers, and there are agents or brokers for the purchaser. The listing person, of course, works for the seller typically, although what if someone comes in, this is more commercial than residential, but to an open house and likes it without an agent or a broker with them and decides to buy the house. Now, who does the broker or agent work for? And so there have always been, in these situations, sort of an inherent conflict of interest. There are new disclosures and new forms, I call them new, they're within the last 10 years, that have been developed that you say that this is an independent person, this person's working for one of the parties to the transaction or facilitating the transaction for both parties. So those are just little things to know and watch out for. But to go back to your question about splitting fees and so forth, if the buyer has an agent or broker and the seller has an agent or broker, typically they'll share the fee that's generated from that transaction.
If you are the tenant, if you're going to be the buyer, and if you're going to lease a property, do you need representation? Do you need your own tenant rep? Do you need just a lawyer? Do you need an accountant? Who do you need to protect your interests if you are the one who is going to make an investment?
All right, so now we're into a commercial realm, and certainly you would want to at least have an attorney who's going to go through whatever lease you're going to be entering into, because in a commercial lease there are a lot of issues that you really need to look at and look at pretty carefully. I have represented a lot of people who over the years have bought franchises in different companies. And so now we have to also match up the franchise agreement to the lease, the commercial lease where they're going. So if you have a 10-year franchise agreement, for instance, and you only have a 5-year commercial lease, that's not going to work. So you have to make sure that the term of the lease is matched up to what you're doing. Typically, the term of the lease can have an option period in it. So it could have a 5-year initial term with a 5-year, and the numbers are negotiable, so we're just making them up, but by way of example, a 5-year option, maybe 3 5-year options. Typically, in commercial leases where I'm representing the tenant, we're going to want to have a number of option periods so that they're only locked in for shorter blocks, but have the opportunity or ability to increase the length of the term for a much more significant period of time.
And to keep with your example, David, if you were representing that one who was about to engage into a lease, would you be likely to, or should that person be interested in those options and use it as leverage to pay less, perhaps, if they were going for a longer period of time as opposed to one chunk in a shorter period of time?
Well, typically what will happen is, of course, the landlord wants more money.
Certainly.
The tenant would like to pay less money. So both sides get a little of something in those transactions where you may have a lower payment for the first 5 years or 3 years or even 1 or 2 years. And then with each option period or each year, the amount that is being paid for the rent goes up.
And is it fair, reasonable, would the leaser, the person who's likely to lease, or you representing that person, likely ask, how much are you going to be making on this? I think that, as I've done some research about that, apparently, depending on whether someone is independent, it's listed with someone, it's not, those factors change and vary greatly. So can you ask? What can you ask?
Who are we asking?
If you're going to be the tenant or if you're working for that tenant, can you ask that person who's showing the house, what's your cut?
The agent or broker? I'm sure you can ask anything. The relevance of it may or may not really have an impact on your side of the deal. If the agent is working for the landlord and
Yes.
the landlord is going to be responsible for their fee,
Yes.
you can ask, but really I think that's usually something that's between the landlord and the agent or broker. And it probably won't have a big impact on the deal unless, of course, we're down to certain amounts of money and the tenant wants to get in there, the landlord wants to get in there, but they're a little bit apart on some of the money, and the agent or broker really wants to get the deal done, so maybe would offer to give up some of their commission to get that done.
Do you generally have more leverage in negotiating than the person who's off the street doing it?
Well, I know more of the issues that they need to look for.
Good
so
point.
we've got the length of the lease, and we're talking now commercial leases.
Yes.
We need to make sure they look for the right zoning and have the opportunity, if the zoning isn't correct, to get out of it, or to ensure that the zoning is correct before they get into it. There's the insurances, and we talked about who's going to cover what insurance. Another thing that you need to understand is what are your additional responsibilities above and beyond the rent? Is it just rent and the landlord's responsible for utilities, trash removal, maintenance, taxes, all of those things? Or are we looking at what might be called a triple net lease, which is a lease where the landlord just collects rent. The tenant pays the rent plus all the other expenses associated with the property, including taxes, insurance, maintenance, and if it's more than one space, if it's common area maintenance, who's paying that charge?
Who benefits most in those kinds of situations, David?
Well, it's really a commercial transaction, so it's an arm's length deal, and the landlord, certainly most landlords would prefer to have leases that just pay them a net amount of money. So a triple net lease is usually something that a landlord would want because the increase in taxes is passed to the tenant. The increase in insurance costs is passed to the tenant. Utilities costs passed to the tenant. So you're just looking at a stream of income. And that's what an investor in commercial real estate generally wants if it's not owner-occupied type of real estate. They're looking for a stream of income. And it also is something that becomes very valuable if it's a good stream of income in terms of selling. And investors in real estate will look at what they call cap rates, which is how much is this investment returning on the investment, so to speak. So if I pay $1 million for this piece of property and it's paying me $100,000 a year net, triple net lease, then I'm looking at a 10% return on my money. So it's a 10 cap lease. Now we're really getting into some very interesting issues because now, in order for that to have certain values, you need to look at who the tenants are as the investor to determine whether or not they're credit worthy, likely to be there, how long is the lease for, and all of those kinds of issues.
And at the beginning of your discussion about this, you were sort of touching on the contract and what those lease agreements might be. But in looking at that, if you are working for that tenant, are you likely to review with them what's in the agreement or the memorandum of intent, and what do you actually look for as being a catching point? You mentioned zoning certainly would be a problem. What about insurances? Obviously title insurance matters, and you would, I guess, work with someone, but sometimes people can do that on their own. But disability insurance, depending on what their business is, and if they're startup, do you have to think about, what do you have to think about in terms of helping them negotiate a lease when, who knows if the business is actually going to last? If it's not a franchise, well, even if it is, maybe it's a three-year
So you
window.
touched on a lot of issues. Some actually, which would be applicable if somebody were buying a piece of commercial real estate, title insurance, which they really can't do on their own. You have to be a title insurance agent to be able to write the policy. And some of the terms of the lease. And since we started talking about leases, we can continue on that path. And what I'll say is, I have different clients who have different interests and different goals in what they're doing or operating. So some of those terms are going to be really much more important to some of my clients than others. For example, I have a client who likes to build restaurants, build them up, and then sell them. So the assignment clause in the lease or subleasing clause is really important to him. It's important to him that he's able to freely assign the lease to somebody else, or in some instances, if it's more than enough property for him to be able to sublet some of the property to someone else. So his concern about having freedom to do that might be more important than someone who's just going to be there for the long haul. It's not something that they intend to sell at any time, although there is some importance to be able to do that. So landlords oftentimes, because they're concerned about the creditworthiness of the tenant, are not going to want you to be able to freely assign the lease to somebody else. However, if you may at some point want to do that, language can be negotiated from being freely able to do that to not be able to do that at all, or somewhere in the middle where the consent to do that won't be unreasonably withheld. So that's a clause that not a lot of people would think about looking at. That's really important. Some of my clients, the signage is really important, and the limitation on signage becomes a big issue. One of my clients who, like I said, does this build-out stuff, what is the contribution that the landlord's going to make towards the build-out that's going to improve his property and theoretically be there well beyond the length of the lease? So will there be a contribution? Will there be a reduction in rent? Can we have a year's worth of free rent while things are being built up and built out, so to speak?
And in the example that you were using about the person who buys restaurants, builds, sells, flips, how do you counsel them in terms of what kind of entity they should be if they're purchasing? ABC company, John Jones, What about LLCs? Discuss
Right.
those a little bit.
So
When does it make sense?
for that person, oftentimes he'll form a corporate entity, which can either be an LLC or a subchapter S corporation. And he does that for different reasons depending on what he wants to do. And we've had this topic before, which could be a show unto of itself.
Yes.
But for his purposes, we'll use it as an illustration of what you can do. So if he's planning on maintaining an interest in the property afterwards, after he's fixed it up and he's going to assign it, he might do a subchapter S corporation with stock and then sell percentages of the stock to investors or other people who might come in and buy it. He could do the same thing with an LLC, but oftentimes with an LLC, he's just going to transfer the entire interest in the LLC along with transferring the lease to the property to the new purchaser who's going to come in and run the business.
Well, that's certainly something to consider, depending on what their short and long-term goals might be.
Right, but the important thing is either one of them will help limit the liability of the person running the business in the commercial real estate, so that they won't be personally liable if someone gets hurt on their property, that type of thing. So you have insurance to cover that. You always want to have insurance anyway, but there's reasons to have limited liability to the investors in the property.
And thinking about the financing, that too could be a topic, I guess, for a show, but in thinking about someone investing in real estate, usually that's not a quick cash deal, but maybe it is. Usually someone has to deal with banks, other investors, collateral. Is that something that you advise, work with a banker to advise? How does that play out, David?
Sure.
What cautions could you share for our to our viewers?
Now we can discuss the differences really between a commercial real estate closing and a residential real estate closing. We went through what goes into the residential real estate closing last time. A commercial real estate closing is much more involved and in-depth because typically you're dealing with a bank that's going to be lending you a greater sum of money than most residential homes are going to sell for. They have an agenda that can be as thick as the closing documents themselves for the residential closing. So there's going to be an attorney for the bank that the borrower is actually going to end up paying for. The borrower is probably going to have his own counsel because there are going to be a number of documents that the borrower is going to have to create. Of course, there'll be the seller and the seller's counsel for the closing. So there's an agenda that's created, and each person who's got responsibility for providing the documents in that agenda is going to be assigned their work. So the buyer's counsel, for example, might be responsible for ensuring that there's documentation to show that the corporation is in good standing with the state. So there's going to be a good certificate of good standing from the Secretary of State's office, from the Division of Taxation. There's going to be votes authorizing whoever's signing the documents to sign the documents. There's going to be secretary certificates saying that these are the people who are in the corporation and these are the bylaws of the corporation, et cetera, et cetera, et cetera. The seller's attorney is going to be responsible for the warranty deed or whatever is going to be transferring the property, and another of the documents. If the seller's a corporation, the authorization for the seller to sell the corporation, the asset. And of course, the bank counsel is going to be documenting the transaction for the bank, which is going to be the notes that the bank requires, and a myriad of other documents that's going to be required by the bank.
What this brings to mind is, in our last discussion regarding the residential side, before you have the closing, there is the request to have full disclosure of all of what the estimated closing costs, so there aren't surprises at the final signing when you suddenly owe tens of thousands more. How does that relate to the commercial end of it? Who discloses what and when?
So one of the things you can do as the borrower is, when you're dealing with the bank, ask them to give you a good faith estimate similar to the residential, but it's a little different because some of it is required disclosures, such as the interest rates and all of those things, and then you're looking also what is the bank accounts are going to cost me? And you try to get all of those things up front. And frankly, they're expensive. So when you're factoring who you're going to borrow money from, you want to make sure, number one, that you're getting a good interest rate, because long term, that's probably the most expensive thing you're going to be paying for. But short term, the expense of their attorneys and all the other charges you're going to have from the bank, you should get those up front.
Makes sense that you would. And what about taxes? There's something like proration. How does that all, is that something that the lawyer takes care of, the banks take care of, or it's in the individual's court to fend for himself? So
it's same as the closing attorney in a residential transaction. This will be very interesting, actually. And it applies in some residential deals too. But you prorate all of the expenses.
Explain that a little bit, because I just tossed that term out, but.
Okay. So, city taxes, they're paid monthly, quarterly usually, or annually, depending on how they're paid, but they're paid for a fiscal period. Some towns and cities are calendar year, some are fiscal year, so the closing attorney needs to know which is what. So just for the sake of argument, a calendar year, let's just say that it's May, make up a date, 12th. And so what they would do, the closing attorney, is to say from the beginning of the year to May 12th comprises a certain number of days. The taxes, let's just say for the sake of argument, have been paid for the full year. And so the seller would get credit for all of the taxes that were paid from May 11th to the end of the year. And the buyer would have to pay, they were paid in advance for that. So that's prorated. Same thing with other bills that may have been paid either for the year or due, where the buyer would get credit and the seller would be responsible for those bills based on a prorating. But also in a commercial deal where there are other tenants, or in a residential deal where there are other tenants, you have to account for security deposits. So if the seller is holding on to $5,000, $10,000 in security deposits, which the buyer is now going to be responsible for, either a credit has to be given at the closing or the money actually has to be transferred. So you have to worry about and deal with that. There are other things in residential and commercial, which could be oil in a tank or other things where there's credits that can be given back and forth. So all of those are dealt with by the closing attorney at the closing.
And when we talk about these contracts that people are about to enter into, there's a loosely tossed out term called contingencies. Gee, we thought we were going to get this and pay that. And before that happens, that actual closing, things happen. Somebody didn't perform these duties or get that done to someone's satisfaction, or didn't meet the zoning regulations that were required. So suddenly, what happens then? That memorandum of understanding, or whatever you thought you were going to have settled, is up in the air. What happens then? Do you end up having to go in and battle it out and renegotiate everything from square one?
Well, a couple of different things. So some contingencies. This applies residential and commercial in many ways, is an inspection, a building inspection.
That's one, good.
So what you were really referring to there is there are some deficiencies. The clause in the contract allows you to get out if you're not satisfied that they can be fixed. Zoning, you can't necessarily, you can't close if the zoning isn't appropriate, so you would have to get an extension in order to change the zoning if it needed to be changed. But certain things, the air conditioning unit isn't working correctly. That can be remedied either by having it fixed before the closing, if it can be, or doing a credit at the closing for whatever the estimated cost of repairing it is, as the parties agree. So that's something that would have to get negotiated either at or before the closing.
Most interesting of them that I had been reading was this, and I assume that you can address it with residential too. One is buying, one is selling. I can't buy unless I sell mine first. Can that be written into both residential and commercial, and that gives the buyer, the would-be buyer, a potential contingency or way out? What does that do, and how do you protect the other party in this case? How does that work?
Yeah,
David?
so a seller's got to be careful as to what kind of language they give and agree to, and of course a buyer does too, on contingencies. So Oftentimes, there are a lot of ways to negotiate that so that there's some protection for both parties, including limiting the period of time that the contingency is in place. If you want to still buy it, but you haven't sold your home and you're otherwise able to buy it, we'll give you 3 months to sell it or something like that. But to give an open-ended extended period is really giving someone an option to buy your property rather than making them buy your property, because they have that contingency for however length of time you gave them, and if it doesn't sell, they can say, "Yep, sorry, didn't sell my home, I'm out."
Or could they say, the market dropped, I know we said 1.2, now I want to give you 3/4 of a million
Sure.
instead.
Well, you can try to renegotiate any terms you want, but certainly if you have the leverage by saying, "I'm just going to opt out," you can opt out and then you can renegotiate a new deal. So there is some leverage with that. So you've got to be careful in what you do with these kinds of contingencies as the seller. And of course, as the buyer, you need a contingency if you're unable to close otherwise. So it really, am I selling the real estate or am I giving an option to someone to buy the real estate? That's what you really have to look at and determine how far you're willing to go with that.
And while we didn't spend a lot of time talking about the financing of it, obviously it's much more involved, as we started to talk about when it comes to buying commercial. If it's a matter of the person putting a bid on the commercial property, but that's subject to his getting an approval for a commercial loan, part of a commercial loan, all of the commercial loan, how viable a contingency is that, and what's respectable on both sides?
Yeah, and just like a residential deal, oftentimes a deal like that has to be contingent on financing, because most people, even with commercial real estate, maybe especially with commercial real estate, are going to borrow a good portion of the amount of money that they're using to buy it. And in fact, sometimes even need more money than that. If it's a business that's going to be up and coming, the commercial lender might also include a line of credit for inventory or repairs or whatever else needs to be done. So it's as important in a commercial deal to have, for the buyer, a financial contingency, a mortgage contingency, like you would have in a residential deal.
If you're the seller, are you able to ask for someone's financials before you get ready to sign on the dotted line? Because, of course, for the residential side, some get pre-approved for a certain amount of a mortgage, and so the seller automatically knows that person does qualify or doesn't right off the bat. Does that happen in commercial, and how does that happen?
So we've got two different commercial transactions where it can happen. Certainly it can happen in a purchase and sales agreement situation where you need to know a little bit more about the buyer before you enter into the deal to know if it's a viable deal. And certainly a landlord-tenant situation, they're going to want to know more about you, and maybe even in that situation ask for a personal guarantee if it's a new business or something of that nature. And then as the buyer's attorney, I'm going to say, let's be very careful about that personal guarantee, and let's limit it to a shorter period of time.
Makes sense. There certainly are so many details to cover while you're looking at that commercial side of it, both on the buyer and the seller side. I can see where you might need a lawyer on both. Sometimes we can get away with having a do-it-yourself. Clearly, this seems to not be one of those cases.
Maybe residential, not commercial.
We hope that this has been helpful to you, and good luck in your residential and commercial transactions. We hope that this has been helpful to you. The law matters. Stay tuned, because the law matters to you.